Navigating the world of work visas can be overwhelming, especially in countries like the United States, where numerous visa categories exist based on the type of work, skill level, employer sponsorship, and duration of employment. Choosing the correct visa is critical, not just for securing legal employment but also for ensuring compliance with immigration laws, maintaining long-term career opportunities, and avoiding potential penalties or deportation. This video highlights the top 10 key differences between various work visa categories, focusing primarily on U.S. immigration but also touching on how similar distinctions apply globally. Understanding these differences is essential for employers, international job seekers, and students transitioning to employment. 1. Purpose and type of employment. The most fundamental difference between visa categories lies in the type of work they allow. For example, the H-1B visa is for professionals in specialty occupations, like engineering, IT, or medicine, requiring a bachelor's degree or higher. In contrast, the H-2B visa is for temporary non-agricultural workers such as those in landscaping, hospitality, or construction. The L-1 visa supports intra-company transfers for multinational corporations, while the O-1 visa is for individuals with extraordinary ability in fields like the arts or sciences. Each visa has a specific purpose and limits what kind of employment is permitted. 2. Skill level and education requirements. Some visas, like the H-1B, demand higher education and specialized knowledge, typically requiring at least a bachelor's degree. The O-1 visa goes further, requiring proof of extraordinary achievement through awards, publications, or international recognition. Meanwhile, H-2A and H-2B visas often target lower-skilled roles and do not mandate formal education. This distinction directly affects who qualifies and what evidence must be submitted during the application process. 3. Duration and renewability. Visa durations vary widely. The H-1B is typically valid for 3 years and renewable up to 6 years. The L-1 visa allows for an initial stay of 1 to 3 years, depending on position and company size, and can be extended up to 7 years for executives. H-2B visas, however, are generally limited to 12 months with few extension options. Knowing the duration helps workers plan long-term career goals and residency pathways. 4. Employer sponsorship requirements. Most U.S. work visas, including the H-1B, L-1, and H-2B, require employer sponsorship. This means a U.S. employer must file a petition on the worker's behalf, proving the job offer, business legitimacy, and the necessity of hiring a foreign worker. In contrast, some visa types in other countries, like Canada's Open Work Permit or Australia's Subclass 482, may allow greater flexibility or self-sponsorship, though usually only in special cases or after previous residency. 5. Quotas and caps. Work visa categories often have numerical limits set by law. For example, the U.S. government caps H-1B visas at 85,000 annually, which includes a general cap of 65,000 and an additional 20,000 for applicants with U.S. master's degrees. When demand exceeds the cap, a lottery system determines who can apply. The H-2B visa is also subject to seasonal caps, which can affect timing and availability. L-1 and O-1 visas, by contrast, do not have annual caps, making them more reliable for eligible applicants. 6. Pathways to permanent residency, green card. Certain visa categories offer smoother transitions to a green card than others. The H-1B is considered a dual intent visa, allowing holders to apply for permanent residency without jeopardizing their status. Similarly, L-1A visa holders, executives, managers, can transition to a green card through the EB-1C category. In contrast, H-2B and J-1, in most cases, are temporary visas without a direct green card pathway, meaning holders must leave the country after expiration or find a new qualifying status. 7. Dependents and family members. Family rights differ by visa type. H-1B visa holders can bring dependents under the H-4 category, and spouses may apply for work authorization under certain conditions. L-1 visa holders' dependents, L-2, have broader work rights, often receiving automatic work authorization. Conversely, H-2B and some other non-immigrant visa holders may not be able to bring family members, or those family members may not have work privileges. 8. Labor market tests and prevailing wage requirements. Some visas, like the H-1B, require employers to demonstrate that they are paying the prevailing wage and that hiring a foreign worker will not negatively impact U.S. workers. This often involves filing a Labor Condition Application, LCA, with the Department of Labor. For H-2B and H-2A visas, employers must go even further by conducting recruitment efforts to prove no qualified U.S. workers are available. In contrast, O-1 and L-1 visas generally don't require labor market testing, which speeds up processing. 9. Application process and timelines. The complexity and time frame of the application process vary. The H-1B process can take months, especially if the visa is subject to the cap and lottery system. Premium processing is available for certain visa types, like H-1B, L-1, O-1, to expedite the timeline, often delivering decisions within 15 calendar days. However, H-2B visas have stricter seasonal filing windows. Meanwhile, the O-1 visa involves heavy documentation and evidence of extraordinary ability, which can lengthen preparation time even if processing is fast. 10. Portability and job flexibility. Work visa holders often face restrictions on changing jobs. For instance, H-1B workers can switch employers but must have the new employer file a fresh petition. L-1 visa holders are tied to the sponsoring multinational company and generally cannot switch to a different employer without changing their visa status. On the other hand, green card holders and citizens enjoy full employment flexibility. Some countries offer more portable work permits, allowing job changes without restarting the visa process. Understanding the key differences between work visa categories is essential for anyone considering employment abroad. Each visa carries unique conditions that impact your job type, length of stay, ability to bring family, and path to permanent residency. Making an uninformed choice can limit career opportunities or result in legal complications. Whether you're a student transitioning to work, a skilled professional being transferred internationally, or an employer sponsoring foreign talent, having a clear grasp of visa differences ensures a smoother, more secure experience. Always consult an immigration attorney or certified legal expert before applying, as laws can change quickly and differ widely between countries.